Good afternoon, and what a beautiful afternoon. I'm sure you're going to, by the end of the afternoon, you're going to say it was worth coming in out of that beautiful weather. I'm Tom McNaught. I'm the Executive Director of the Kennedy Library Foundation, and on behalf of Tom Putnam, the Director of the John F. Kennedy Presidential Library and Museum, and all of our library and foundation colleagues, I want to thank you for coming today. Let me begin by acknowledging the generous underwriters of the Kennedy Library Forums, our lead sponsor, Bank of America, Boston Capital, the Boston Foundation, the Lowell Institute, Raytheon, and our media partners, the Boston Globe and WBUR. Nancy Gertner will go down in Boston lore as a legend. She is a trailblazer who broke through the ceiling and continued right on into orbit. As a criminal defense attorney, she is up there with the likes of Clarence Darrow or F. Lee Bailey. If you were in trouble and you were seeking justice, you asked for Nancy Gertner, particularly if you were a woman who was rarely accorded the same access to justice as were men in the 1970s and 1980s. Judge Gertner's autobiography, In Defense of Women, Memoirs of an Unrepentant Advocate, is literally a page-turner as we follow the criminal defense of Susan Sachs, or of a battered woman who killed her husband, or of a woman discriminated against in employment or denied access to health care. But Nancy Gertner was also an equal opportunity defense attorney who also came to the defense of men. Just as important, her book is an historical account of the path to civil liberties in the Commonwealth of Massachusetts. Now, this book is on sale in our museum store, and Judge Gertner will be signing copies after the forum. With us today, I'm delighted to say, is Judge Gertner's husband, John Reinstein, himself a renowned advocate for civil rights, as the legal director of the American Civil Liberties Union of Massachusetts. John, welcome. Also with us today are John and Nancy's children, Stephen, and I believe their daughter, Sarah, and their grandchild, Liam. But anyway, Stephen, welcome. And it is a particularly personal pleasure for me, extraordinary pleasure, to welcome back an old and dear friend of the John F. Kennedy Library and the John F. Kennedy Library Foundation and the staff of both institutions, Ambassador John Shattuck and his wife, Ellen Hume, who are with us today. Those of you who used to come to the forums the last 8 years will remember that it was always Ambassador Shattuck up here introducing the forums. So we want to welcome them and their children, Peter and Misha Shattuck, as well. John, as you may have known, is now the president and rector of Central European in Budapest, Hungary. They actually are on their way back to Budapest, Hungary today. But he and Nancy were classmates at Yale Law School, where they both majored in how to be a Boston Red Sox fanatic. After more than 2 decades as an acclaimed criminal defense lawyer and civil rights activist, Nancy Gertner was appointed by President Bill Clinton to the United States District Court for the District of Massachusetts in April of 1994. In September, Judge Gertner will retire from the federal bench and become part of the faculty of the Harvard Law School. For many of us, the first we learned of Judge Gertner's retirement was in a column written for the Boston Globe by our moderator today, Brian McGrory. It was a pitch-perfect piece of writing which captured the groundbreaking contribution Nancy Gertner has made to our justice system. After reading Brian's column, I sent an email to both Nancy and John Shattuck over in Budapest saying, "Tell me it ain't so. The U.S. District Court without Nancy Gertner is like the U.S. Senate without Ted Kennedy." And it is so very, very true. Linda Greenhouse of the New York Times, who covers the United States Supreme Court, said of Nancy Gertner, "Her clients were lucky to have her then, and the legal system is lucky to have her today." Judge Gertner is a graduate of Barnard College and Yale Law School. She is a recipient of numerous awards, among them the Thurgood Marshall Award from the American Bar Association's section of Individual Rights and Responsibilities. She is only the second woman to have received that award, the other being Justice Ruth Bader Ginsburg. Judge Gertner was described by the Massachusetts Lawyers Weekly as one of the, quote, most influential lawyers of the past 25 years, and it was voted by its readers as the best federal judge in Boston. Judge Gertner has combined an academic career with her active legal practice and then with her judicial practice. While a lawyer, she taught at Boston University Law School, Boston College Law School, Harvard Law School, and as a judge, she taught at the Yale Law School. Since becoming a judge, Judge Gertner has traveled widely, teaching women's rights and human rights. Those amongst you who come to our forums often or listen to our forums on radio, WBUR, know that we invariably draw a connection between our forum guest and John F. Kennedy, and today is no exception. Nancy Gertner and her husband John live in President John F. Kennedy's boyhood home in Brookline, Massachusetts, the same home where Eunice Shriver, Patricia Lawford, and Robert F. Kennedy were born. Is it a coincidence that Nancy Gertner lives in the same home as Eunice Kennedy Shriver, herself a trailblazer for the rights of the intellectually challenged, or John and Robert Kennedy, who called discrimination of black Americans a moral crisis? We think not. And it was Senator Edward M. Kennedy who nominated Nancy Gertner to the U.S. District Court to President Bill Clinton. But clearly the most important connection has been Judge Gertner's commitment to the ideals espoused by President Kennedy. When I think of Lady Justice with the blindfold and scales, I can't help picture her wearing red, or at least accessorized with a bright red scarf. Our moderator today is Brian McGrory. Brian has reported stories for the Boston Globe from every one of the United States and from all over the world. Before becoming a twice-weekly columnist, he worked as a suburban reporter, a city reporter, a roving national reporter, and as a White House correspondent covering the Clinton administration from the newspaper's Washington Bureau. He is also the author of 3 best-selling thrillers, The Incumbent, The Nominee, and Deadline. I mentioned earlier the Wicked Good column that Brian wrote where I first learned about Nancy Gertner retiring. I can think of no better way to begin this afternoon's forum than to quote from Brian's column. Quote, he wrote, "Nancy Gertner is retiring as a judge. This is not a small deal. Actually, it's a profoundly big one. Gertner is many things to many people. She is an unapologetic liberal. She is an unrepentant advocate. She is a civil libertarian of the highest order. But she's also something else, something greater than the sum of these various parts. She is a voraciously fair judge who uses her love of the law and the benefits of her sizable intellect to give refuge and recourse to those who need it. An entire region will miss that." Ladies and gentlemen, please welcome the Honorable Nancy Gertner, U.S. District Court Judge Extraordinaire, and Brian McGrory of the Boston Globe.
Thank you very much, Tom. It is an honor to be here today with this arduous duty of somehow trying to draw Judge Gertner out of this shyness that is her trademark. Tom mentioned one column that I did on Judge Gertner. We actually met over a different column, much different circumstances. 6 or 7 years ago, right. Judge Gertner made an uncharacteristic bad ruling from the bench. And I did my newspaperly duties and called her on it. I thought I was doing her a favor, letting the public know. A couple of days later, my phone rang in the Globe newsroom, and it was Judge Gertner on the other end of the line, telling me things about myself I hadn't realized before. And at the end of the conversation, she said, "So you want to have lunch?" So I figured, why not? So we got together a week or so later, and I will tell you, she is not just a great source, but a wonderful friend who it has been a pleasure to get to know all these years. I'll also tell you something else about the book that she wrote, something that Nancy's probably not allowed to say, and that is, it is absolutely terrific. I have spent several really pleasurable days reading it. I know as somebody who has written a couple of books, it's always aggravating how quickly people can read them after it takes so many years to write them. but it is a compliment that I read it in 2 sittings. It gives you a field box seat, the $120 variety, into the history of Boston in the last 35 to 40 years. By the way, I had no idea you were this old, but...
At some point I'm going to interrupt. I just want to make it clear.
It also gives extraordinary insight into the women's movement, how that has changed, the law profession. It is a stunning book at many levels, but beyond any of that, it is truly a writer's book as well, something that, as a writer myself, I found somewhat aggravating that a federal judge could be this eloquent in her book. She tells it through the eyes, as Tom mentioned, or through the cases of several defendants and plaintiffs who you represented. Claire Dalton, who was denied tenure at Harvard, who never should have been. A woman named Lisa, who was accused of murdering a husband who had been torturing her. A woman named Marcia, who was violated by her psychiatrist in every possible way. Susan Sachs, a young Tufts University student who got caught up in a crime that went beyond anything that she expected to happen. Matthew Stewart, the brother of Charles Stewart. Paul, a slightly built college student who was accused of rape, a rape that he didn't commit. And you tell it all in almost John Grisham-like fashion. I am at the edge of my seat waiting to see how these things turn out. Beyond that, and we will get to questions, there is a wildly entertaining cast of supporting characters. Berna Aronson, who was Susan Sachs' lover, who wears leather vests and a huge keychain looped into her belt, who becomes your investigator. The Nancy Drew Associates on your all-women legal team representing Susan Sachs, who did jury investigation. Iffy the car that you never knew was going to get you where you needed to go. Samantha the Beagle. It was all wonderfully done. And then right down to your husband, John Reinstein, who you have this great quote about. When the two of you who had worked together for many, many years finally established the relationship you have now, your quote was, "Love, work, mashed potatoes. It couldn't have been any other way." Now, in all of these characters, there are 2 that stand out even beyond them, your mother and your father, Sadie and Moish. And I've always thought that you judge a person's character now by where they came from. So I'd like you to tell us a bit about how you grew up and the role that these wonderful parents played in your life.
I have to say that we have not coordinated this very much, but he asked me how to pronounce Moish. And we had a recitation about how to pronounce. You did it very well.
Thank you.
Very well.
Thank you.
I was born on the Lower East Side of Manhattan. Not the classic. People have a model of a middle-class Jewish family pushing education. That wasn't the model that I had. My mother and father. My mother didn't finish high school. My father had just a few months of college, and was very, very traditional. Liberal Democrat, but traditional about women, totally traditional about women. So my mother wasn't allowed to drive, my mother wasn't allowed to work, and he didn't know what to do when he had 2 daughters. And what I tried to describe is how did I come from this and love them as I did? How did they manage to get me to be something so totally different than either of them were, but attached to them and devoted to them in no uncertain terms? And I describe in the book, because the process of writing this was trying to tease out how that happened. What would happen is that my mother, at the end of the meal, would kick me out of the kitchen. Don't do the dishes, go do your work. So it was sort of an implicit, don't be like me, be somebody else. All the while telling me when I got into Yale Law School that I had priced myself out of the male market. So there are sort of two themes going on here. And my father, who, I love to tell the story about watching the 11th hour news with John Cameron Swayze, who had a locked jaw. John Cameron Swayze. And at the end of the news, my mother would go to bed, my sister would go to bed, my father and I would debate everything that had gone on. And so what does that prove to you? whatever he said, and said all the time about women and the women's rights movement, he was engaged with me. He would hear what I would say. We would argue until 2 in the morning. And then actually, I don't have this in the book, when he died, John and I cleaned out his apartment in Flushing, Queens, a very small apartment. And by the side of his bed was every article that had ever mentioned my name. And in fact, John Shattuck likes to tell the story, which is a story that I have told when I joined my first firm, Silverglade, Shapiro, and Gertner. My father used to call up just to have him say the name. You know? Silverglade, thank you very much, and hang up. So what they said was so different than what they showed me and what they were cheering me about. And I lost a major cheerleader when they died.
Please don't deprive the audience of the story you told at your swearing in as a federal judge. My God. Well,
the confirmation process had not been easy, which is an understatement. And so when I finally got there, it had not been easy on a number of levels. One is someone like me is not typically a federal judge, and so there was a lot of pressure for Kennedy to actually withdraw my nomination. But and my father had also died 3 days before Clinton called me up to recommend me for the bench. So I was a little shaky. I told my father before he died that I was going to tell this story if I ever got to be confirmed, and this is the story. It is 1971. I have graduated Yale Law School. I have all these honors. I'm about to go and clerk for a federal judge. My mother and I are having this amazing fight, and all the women in the audience, there are kinds of fights you have with your mother that you don't have with anyone else in the world. You say things that you would never say to another human being in the world. So we were just going on at it for a long time. What were we fighting about? Sadie wanted me to take the Triborough Bridge toll takers test, just in case. You never know. So I told this story at my swearing in, and when the audience finally calmed down, I looked up at the ceiling and said, "Ma, a government job."
There's a very touching passage in the book towards the end about a conversation with your father after you were first nominated, in which he called up and you were talking about it, and he said, "So you need to go before the state legislature." And you said, "No, Dad, the United States Senate." And he said, "The Judiciary Committee that we've seen on TV." And you said, "Yes, Dad." And there was a pause, and he just said, "I'm so proud of you, Nance." It was just a beautiful moment in the book. Tell me about the process of writing a memoir, how you came to it, how you decided to do it, whether you found it personally transformative in any way.
Well, it came about to some degree by accident. It took 9 months to confirm me, and while I was in the process of being confirmed, I was supposed to go through all my stories. And as I describe in the book, I was supposed to go all through all my stories. Every judicial candidate has to do this, to see what would embarrass the president. I went through all my stories. I decided that nothing I had done should embarrass the president. Then I have to put in a footnote. The president was my dear friend Bill Clinton. I didn't think he could be embarrassed. I just had to get that in. But the process. So I had all my stories, and what I had found was that I kept on running into people who would say to me, "You know, I followed your career from the Susan Sachs case, not just people but women, and I'm proud of what you've done." And I began to feel that although this is a wonderfully narcissistic enterprise to write a memoir, that it was also important for women of my generation to tell our stories. That the next generation of women had to understand how fragile these gains were, how in just only 20 years before, people were saying things to me in court that were just astonishing. So I thought that it was important to tell the stories. I think it's important for all women of my generation to tell the stories so people understand how fragile these gains are. But what happened was I was confirmed. So I became a judge, and I had to write this book while I was judging, which meant I had to sort of have two hats on all the time. I would be judging during the day and then trying to reconstruct the person that I had been beforehand. And it's interesting, when I wrote it, it is transformative because you begin to see the judge emerge from the advocate. The early stories, particularly Susan Sachs, I write about how hard it was for me to empathize with the victim, with Officer Schroeder, who was killed in the bank robbery, because all my energy was being spent on being an advocate. I couldn't have, it was like not being able to have two thoughts in the same brain. By the end, by Stewart, by the battered woman who killed her husband after a couple of hours had passed between her beating and the murder, by the end, I was able to keep those two thoughts in mind. Here's what I believe. Here's what I think. I'm troubled with this area of the law. I understand its implications, but I'm going to represent this woman to the nth degree. That kind of dualism you use as a judge. I never pretended I had abandoned my politics. I was who I was. But you had to learn how to be a different person, be guided by different rules in being a judge. You didn't forget who you were, but you understood that the setting called for different kinds of judgments and a different kind of persona. And that ability to have both of those feelings in you, it seemed to me, was, I see in the book. I'm not sure anyone else does, but I see it evolve.
No, it is absolutely apparent. How long did the book take you to write?
6 years.
And would you, I'm betting we have some aspiring writers out here, would you block off weekends, weeks, a couple of hours in the morning? How would you do it?
6 years, and I had 2 small children and a stepdaughter who was a teenager. So it was New Hampshire. Successive August in New Hampshire is where I wrote the book for the most part, because then I could be someone else. Then I didn't have to struggle with being a judge by day and, Gertner the advocate by night. So it took a long time, and made worse by the fact that I didn't know that I could do it. I knew that I could be a judge. I knew I could be a lawyer. This writing stuff I wasn't so sure about. So it's wonderful to hear you talk about it.
Now, you have one passage here when you talk about how fragile the gains are for women. I'd just like to read one quick paragraph, if I could, and then ask you about it. You were representing Susan Sachs, who, as I said, was a Tufts University student. Brandeis, I'm sorry.
Tufts is going nuts now. It's Brandeis.
Brandeis University student, thank you. You were representing her in one of the highest profile cases in the country, which you happened to get almost right out of law school, if I'm reading this right. A police officer, Walter Schroeder, was shot at the scene of a bank robbery. The bank robbery was meant to fund some anti-Vietnam War protests. And so there you are in the courtroom in Suffolk Superior Court. This is all going on in downtown Boston. And you write here, to the press, I was invisible. To the prosecutor and the police, I was a rabid feminist radical representing everything they reviled. To the lesbian feminists around me, I was, quote, terminally heterosexual. A feminist with eye makeup, shaved legs, and a bright red suit. A carnivore while they were vegetarians. Far too moderate, too much the compromiser. To Susan Sachs's family, I was her proxy. And while representing Susan aligned with my heart, my politics and my heart, I felt I was neither fish nor fowl, neither a member of the Lawyers Club nor of the Defense Committee, neither Susan's friend nor just her lawyer. It was a lonely perch. From that very beginning, your first trial, how did women in the law evolve by the time you got to representing Claire Dalton, which I think was your last major case?
Well, in the Sachs case, I was literally, me and my staff were the only women in the courtroom. The judge was a male, the prosecutors were male, the reporters were largely male. I mean, there was literally no other women in the courtroom. And while I remember during the Clinton administration, there was a notion about bean counters and whether numbers matter. Numbers matter. Numbers matter. It matters a great deal when there are other women around. I felt like I was carrying the banner of all women. So if there had been a moment during the trial that I wanted to collapse or wanted to turn down the case, I felt like I just couldn't sort of cave into that stereotype. And so, but the problem was that Susan, on the one hand, that's what every trial was. I was the only woman in the courtroom. Susan figured she was going to spend the rest of her life in jail, and she was determined to have her last moment on the stage be consistent with her feminism. So she wanted an all-woman team. So we were dealing with a woman on trial for her life, just facing life imprisonment, the tremendous difficulty of the case, maneuvering your way through the sexism of the Suffolk Superior Court. I talk about the prosecutor trash-talking me. Literally, I'd walk into court and he would, if I was wearing a loose-fitting dress, he said, how dare you look pregnant when you're representing that lesbian? I mean, just sort of so it was balancing the challenges of the case, her life in my hand, and this sort of persistent blather about sexist blather from the elevator man, I might add, to the judge. By the time of Claire Dalton's case, what's funny about Claire Dalton's case is Claire Dalton sued Harvard for denying her tenure at Harvard Law School. There's a certain irony to my joining the faculty at Harvard Law School, I might add. Very sweet irony. But I was representing Claire Dalton. Margaret Marshall, the retired justice of the Supreme Judicial Court, was Harvard's general counsel. Joan Lukey, a very prominent trial lawyer, was representing Harvard. There was a woman mediator, and there's a wonderful scene where we are basically hashing out if there's any way to settle this case. And at some point, it was like 4 o'clock in the afternoon, all the women looked at one another and said, let's cut to the chase here. What can we do? It was a very different setting. It made all the difference in the world being surrounded by other women, so that you could focus only on the job at hand rather than dealing with all the indignities that you had to suffer when you were the only woman in the courtroom.
Do you still see the gains as fragile, or do you think there's no sliding back at this point?
Oh, I think that the gains are fragile. There's some sliding. There's some things that won't change. We now can see women lawyers in trial lawyer positions. You see that on television. Young women have in mind Hillary Clinton and Ruth Ginsburg in a way that I couldn't have in mind models like that. But the economy has set back the progress of women in the legal profession quite extraordinarily. Mm-hmm. The first people who are being let go in the big firms are women. And there still is the notion that after, 20 years of 50% of the law school classes being women, the notion that we're still dealing with so few women on the bench, so few women on the Supreme Court, and it's still an issue. Will we replace Gertner with another woman on the District Court of Massachusetts, for God's sake? There should be enough in the pool that this isn't even an issue. Yep. So it's still an issue.
And there are, of course, certain and obvious obstacles when you're a very prominent woman lawyer. Obstacle may be the wrong word, but there are things that you need to overcome that men may not. One of them is motherhood. I'd like
overcoming motherhood.
Well, as soon as that was coming out of my mouth, I could already hear your response.
This is our relationship, right?
Thank you. Let me read a quick passage in your very sentimental words about having your first child. I recognized this man immediately as he approached my bed. I hadn't had any sleep. 3 days of labor, up all night, and I was a, quote, older mother to boot. Menopause and birth were running neck and neck. But no matter how groggy I was, this was not the face I wanted to see. I had approved 7 of the 8 obstetricians who might be on call when I was ready to deliver, but not him. I was explicit. I had cross-examined this man in a medical malpractice case. He was a defendant's expert. I was representing the plaintiff. I had challenged his medical qualifications. But there had been a last-minute change, and now he, of all people, was about to cut me open. Actually, he was resisting it almost as much as I. Because he assumed that I was a mega-feminist wanting the most natural birth imaginable, he was determined to avoid a cesarean section at all costs. But after almost 60 hours of labor trying to deliver a baby that seemed not to want to leave my body, I was prepared for anything. I had to persuade him that I would not complain or worse, sue, if he simply operated. Quote, operate, enough already. I promised I won't call the National Organization for Women. Not sure why I read that, except for I love the passage. But tell me about how childbirth, motherhood, changed the way you went about the law, if it did.
Well, first I have to say that that chapter was edited seriously. I had an opening, which my editor wouldn't let me say because it was too dirty for a judge, but I'll say it here. The opening paragraph was, I recognized him immediately from between my naked, parted legs. They didn't like that. They didn't like that at all.
If your editor is here, I thank her. And you should too.
It's a little hard to recover from that, but it's very interesting. It's partly the importance of having people on the bench with different experiences, because being a mother and dealing with juggling family and work made me understand more of the people I was representing who were juggling family and work. In addition, immediately after, when Stephen was, I believe, 6, and I think, no, it was about 4, and Peter was 4 and Stephen was 6, one of the cases I got in the book was a rape case of a young man, a 19-year-old Brandeis student who had been accused of rape. And I had never taken a rape case before. Not that I didn't think people who were accused of rape deserved to be represented. It wasn't that. It was just that I threw myself into everything that I did. I had become an adept cross-examiner. I did not simply want to reduce a woman to tears on the stand, reduce the woman complainant to tears on the stand. I just didn't want to. I wanted to do other things. Mm-hmm. But this young man was a friend of a friend, and the story he told suggested to me that it was a date rape kind of thing, and the story he told suggested to me that he was innocent. The woman didn't make a complaint until 10 months later. She had invited him to her parents' house a month after the supposed rape. He was a virgin. This was his first sexual experience. He was about 4'11". I mean, nothing made sense as rape under any set of circumstances. And I have to admit that having sons who were young at the time made me look at this as a different case. I felt for him, and I felt what a false accusation was going to mean to his life, and that prompted me to take the case. But really, just in general, the notion that you need to have people who are not machines on the bench, who know what human beings go through, and part of what human women go through is childbirth and rearing children and balancing work and family. So it transforms the way you look at everything.
And you would talk in the book about showing up in court with one of your sons sniffling
snot.
Okay.
Not to put too fine a point on it.
Thank you.
Right.
On your red suit jacket.
Right. Or vomit. It was a good one. I was in the middle of a closing argument. I looked over and I saw a, rice cereal epaulette. It was a very, that also, you have a whole different view of the world. The world is no longer orderly when you have children. It's just a very different scene.
Your world didn't sound all that orderly to begin with when
no,
you were.
That's true. That's true.
In the writing business, in the newspaper business, when we write long stories, we like to put fun little facts throughout, and we call them gold nuggets. In your book, it's filled with gold nuggets along the way, gold coins. You have an anecdote about a University of New Hampshire professor flinging a full cup of hot coffee at you. Your quote, I think, was, "Luckily it missed." You have a stained dress years before Monica Lewinsky that could have proven harassment or much worse, actually. You have the counterfeiter whose case you took who paid you in a $50 bill. And you didn't have the kind of heart to say, was this real?
Nobody wanted me, so I was so excited he wanted me to represent him.
Does Yale Law School, one of the finest in the nation, prepare a lawyer for these kinds of scenarios?
Oh, not remotely. Not remotely, especially.
What does?
Well, in one sense, Moish did. My father did. Because the late night debates with someone who completely disagreed with me, as I say in the book, taught me to disagree and love, to respect and fight. And I think that actually affected my lawyering, and certainly affects my judging. You'd go before a jury and who you knew didn't like much the person you were representing, and the enterprise was very similar. You had enormous respect for them, and enormous respect for the institution, but how do you bridge the gaps between what they're thinking of and what you think that the jury should do? In fact, I used to call my father and run my arguments by him. There's a wonderful story in the Sachs case when this was when I was about to represent Susan, and I called up my father to see what he would feel like when my name was all over the paper representing this radical anti-war activist. And my father had a pinochle game and a paddleball game, and my mother had a mahjong group and a poker game, and I just could imagine what the discussion was. So I call up my father, and my father says, I want you to take the case. I want you to work very hard. I want you to win. And then I want Susan to walk across the street and be hit by a car. Right? So balancing all of that, but I came from a background where this was not a clear trajectory, and so with every side road, the looking down at the vomit on your shoulder was part of life.
Talk about the empathy that you feel with the people you represent. Throughout the book, you make repeated reference to empowering your clients, which is a style of lawyering that is very interesting. Talk about that a bit.
Some of it was the 60s. I mean, the book is, my memoir, but it's also a story of the 60s. And so in the 60s, we were rebelling against just about everything, about professionalism even. I talk about how I used to bring a shopping bag into court because I thought a briefcase, was an emblem of my difference from my clients. So I'd bring a shopping bag, which was not a good idea.
And you stopped, why?
Once I whipped out a file and something was dangling off the end of the file. And I decided this was not a good thing to do. So we were Democrats, and it was a small d. We thought that it was terribly important to, if you were representing welfare recipients, it was terribly important not to be the distant lawyer, but to show them how to represent themselves. And that was the kind of lawyer I was. So with Sachs, we would be talking about what the strategy was, and really throughout the book, so that the ultimate decisions were decisions that I guided, and I gave people what the lay of the land was, but ultimately was a decision that they had to make. I think, as I said, it really came from the movement of the 60s more than anything else. It was democratic and representational, and the process was as important as the outcome to me.
And you wanted the jury, if I'm reading it right, to see the collaborative nature, correct? I mean, you would, with Susan Sachs, constantly be huddled at the table,
right,
talking back and forth, and you wanted the jury to see that. And
it's a question of symbols, and when you walk into a court and you're leaning in this direction, your client is over here, the jury, you communicate to the jury that, I don't like him either. And it was terribly important to humanize the people that you represent. When I became a judge, I actually had enormous amount of trouble with the perks with the symbols of the judiciary. we tell these wonderful stories about how I kept on forgetting to put on my robe. This will be in the next book. So I would walk out on the bench just like this. My clerk would turn around and say, Judge, you're missing something. And I would, just go on. And so finally they hung the robe in the doorway like a passive seatbelt restraint, so I had to walk into it. But undaunted, I then would walk on the bench with my pocketbook and my robe. I just never got the symbols down right.
And that would carry right through to your closing arguments, correct? Talk about that for a second, about how you almost made juries believe that you were the defendant in many ways.
That was mostly in the battered woman case, because what happens in the criminal cases in particular, not so much in civil, is the defendant comes to the table accused of a crime, and although people are not supposed to assume they're guilty, this never happens. In fact, people assume they're guilty. And people will distance themselves, as I said, in the way a lawyer might, from the defendant. So the enterprise was always trying to suggest, trying to communicate to the jury that this was a human being. And I have to admit that in my representation of them, I was so committed to the representation that I would grow to care about the people that I was representing almost without exception. You'd find something about them to care about. So the enterprise in a closing argument was to communicate that to the jury. And in Lisa Grimshaw's case, it was particularly important. I did that closing argument in a chair in a fetal position, because that's what she had described, what this had been like for her, waiting for her husband to break down the door and beat her again. And I wasn't convinced that the jury would her story comes out as question and answer, whereas I could tell a narrative. So I wanted to make sure that narrative enabled the jury to understand her.
I hope you know what I'm talking about here. Lawyers who have an aha style.
Yes.
Explain what that means. This is in the book,
right.
And it's meant to contrast many male lawyers of the day with you.
Right. F. Lee Bailey, for example, had an aha style, which meant the witness would be on the stand and say, you'd ask the question, isn't it a fact that today is Tuesday? And the witness would say, no, it's Wednesday. And the lawyer would go, aha! As if this made a difference to anyone in the galaxy. It was, in fact, a nothing. And I was not, and the voice would be booming and fill the courtroom with his presence. I'm a short person with a high-pitched voice. I had to figure out some other way to do it. And what happened over time is that you began to realize that you actually had a way of cross-examining people where they would communicate with you and say things that perhaps they shouldn't in the course of the cross-examination, and I didn't have to yell at anybody or boom to do it. What was interesting then was that there were no women models of lawyers. Now you see them on television, but there weren't any women models, and you had to figure out a way to make this package effective. When I looked younger and had hair down my back and had this high-pitched voice that when I got nervous sounded just like Minnie Mouse, which is true.
What's it like to wait for a verdict?
The most excruciating time imaginable. I still have trouble even as a judge, and I don't care which way the case comes out, but I'm still tremendously nervous. It is a remarkable institution to give ordinary people the ability to understand the complexity of law in the way judges do.
And aside from an election, there's probably nothing in our society that has more drama than this group of jurors going behind closed doors to figure out whether somebody may go to jail for a long time or whether somebody may benefit by being awarded a lot of money. How would you and the defendant or plaintiff pass the time when you were a lawyer?
Well, there were different ways. It depended on whether the defendant or plaintiff was was in custody or not. I tell the story when Susan Sachs's case went to the jury. It wasn't my first case, but it was close to my first case. And I went to the bowels of the Suffolk Superior Court in my lawyer costume with my briefcase, and then inside I'd sit in the cell with her, and she had a little television, and we were watching Bonanza reruns. I would change into my Minnie Mouse T-shirt. It was all part of the same theme, and I, in fact, snuck Chinese food in my briefcase, and that's how we passed the time waiting for the jury verdict. But otherwise, you just are, you're incapable of doing anything else. It's a very frightening kind of moment.
You have an interesting line in the book. Well, you have many interesting lines in the book, but you have you say that innocence is irrelevant in terms of an appeal on a case. That really struck me for some reason. It not necessarily in a good way. What did you mean by that?
Well, that's actually going to be in the second book a lot, but in any event, the appeals are about trial errors. So that means that appeals are only about what went on at the trial, not what the truth is. It's not did the person in fact do it or not, but did the judge make errors? Did the lawyers make errors? Actual innocence is irrelevant. DNA has begun to change that, because all of a sudden we now see trial errors in one box, and oh my goodness, we can actually prove innocence or guilt in another box. But the courts are having a hard time, and the Supreme Court in particular, in reconciling the two. In other words, you in your column would no doubt, and I think this was actually the theme of that first column that we got to know about, would be concerned about a heinous criminal getting a conviction, and the victims can be satisfied that it's over. But the problem is the process is flawed, and we've seen that more and more. And appeals are the way we uncover the flaws in the process, and DNA testing is to some degree the way we determine whether or not it was an accurate result. On the one hand, for victims, this means that cases can go on way longer than they would want. On the other hand, liberty hangs in the balance, and it seems to me we have to let these proceedings go on for longer.
Because you brought it up, what was your relationship with the news media as you were, getting this fame as one of the star lawyers in Boston? You came from, I'm not going to say nowhere because you came from Yale, but in the legal community in Boston, where women were few and far between, and women stars were even more scarce, you took on the Susan Sachs case. You essentially won, and stardom was right there for you. How did you deal with the news media? How did you use the news media to your advantage, both for yourself and your clients?
Well, the Sachs case was actually very interesting because the Globe and the Herald and the TV stations decided that since this was about the anti-war movement, younger reporters should be asked to cover it. So it was very interesting is that I was a baby and they were all these other reporters, and this was their first big event. I realized very early on that I had to talk to the public as well as the jury and as well as the judge. And in the Sachs case in particular, it was terribly important to get the public to understand that she was not the monster that had been created by the press. Because the press gets the government facts. Someone, a long investigation, all that comes out. We've had this discussion actually before. All this information comes out. It's all government information. Then the person is indicted, and then the rules require lawyers, in fact, to be very discreet about what they say. But at that point, the damage is done. I would try to figure out a way of talking about my client consistent with the ethical rules and talk to the press. Because, as I said, the judge knows the press is there, and your view of the case is determined to some degree by the media. So I developed relationships with numbers of people in the media all the time, and whenever I could, I would talk about, when it was ethically permissible, I would talk about the case. I would talk about what I was doing. I believe that ought to be done by judges as well.
I love hearing that, but expound on that.
Well, it is no longer the case that judges are, sort of brooding, omnipresent figures afar. You are trashed in the press, or for the most part, you get 24/7 news coverage of what you do, and it seems to me we can no longer count on the public assuming we're doing the right thing, the public assuming that we're dignified and assuming that we should get the respect that previous generations have had. I actually think we have to work for that, and that's why one of the things that I've been criticized for as a judge is I believe firmly in cameras in the courtroom. I believe that judges should, that there's a way of talking to the media. You can't talk about a pending case, but you could explain to people what's going on and what the context is. And because of the nature of 24/7 coverage, there has to be a pushback, and that pushback ought to be our talking about what it is we do. And I think I learned that from my relationship with the media all along. I never, ever, ever would allow my office to say, Gertner can't be reached for comment, even my judicial office. That was in his article, his column, which made me so angry. Gertner could not be reached for. Gertner will comment on anything. But it is, I mean, it's the public, the media, it seems to me we act on a public stage, and you can't expect judges and the lawyers and to be totally divorced from the way in which a case is spun in the press. This is particularly the case now when before I became a lawyer, there had been a number of celebrated cases where, in fact, there was a question of whether the charges would be dismissed because of pretrial publicity. We can't dismiss charges anymore because of pretrial publicity. Otherwise, numbers of cases could not be prosecuted. So all the players in the system have to engage with the media. And our story is a classic in that regard.
It is.
I didn't call you up. I wrote a nasty letter.
Is that what it was?
I was great at nasty letters.
I think you hurt my feelings, but
and I sent the letter, to the ombudsman of the Globe.
Oh my God!
Yes.
You're trying to get.
And the story is slightly different, actually, because what happened was.
There we go.
The ombudsman.
There we go.
The ombudsman concluded that you're a columnist and you could have said what you said. That was okay, but then your friends and my friends. That your friends called me up and said, he's really a good guy. And you had people calling you and say, she's really okay. And that's when we started to.
I think.
You got your details wrong, Brian.
I think. I think what really happened here was that you had asked some of your friends at the Globe, who is this jerk? And what they said was.
That's actually cleaner than what I said.
What they said was, he's not a jerk at all, and
right.
you two should get to know each other. It's just staying on the press-judicial relationship. I mean, it is incredible that we still don't have cameras in the courtroom, that we still have these sketch artists sitting in the courtroom drawing. We don't have any kind of cameras in the courtroom, never mind live.
It's federal. We do have it in state.
In federal, yes. Up until a year or two ago, I don't think reporters were allowed to have laptops or anything else in the courtroom. When you stepped into a federal courtroom, you were stepping into the 19th century.
Right.
And that doesn't lend itself to kind of the public square that we live in now. So I know I've spoken to Wolf about this, Judge Wolf, and you certainly have, and I love hearing what you're saying, and I hope you pursue that more.
Well, it's even worse than that, because as newspapers' budgets are declining, the only way you're going to find out about what's going on, you reporters are going to find out what's going on in court, is if there's going to be a video streaming. I mean, what we were trying to do was set up a website where proceedings would be video streamed gavel to gavel, and it would enable then a very changed journalistic community to be able to see what's going on as well and to communicate about it. So that has to change, but the problem is that there's a generation gap between the judges and and the rest of you. Judges see this really as an intrusion. And also the Chief Justice of the Supreme Court is unalterably opposed to cameras in the courtroom. Nothing will much change in the federal courts until that changes.
Now, have you felt muzzled in the
Me?
last 17 years? Yes.
Yes. Yes. There are times when I will speak and I will literally sit down and go over in my head to see if I've said anything that would trigger an ethics complaint on the one hand or someone moving to disqualify me from a case on the other hand. And and in fact, I was once disqualified from a case, a high-profile case as a judge, because I had explained what a class action was to a reporter. I had denied a class action in a particular case. The reporter was covering that. I explained to him what a class action was. He quoted me in the press, and I was then removed from the case because I had talked to the media. So yes, I felt muzzled. I've done what I could to speak in a different way, and I'm supposed to speak through my opinions, and of course the problem is that most judicial opinions are written in Urdu, or some language that no one recognizes. So I've tried to write decisions that are in English so people can understand what I do.
Well, you're famous for that, actually. Your decisions are something that can be easily digested by everybody involved, and it makes the judiciary a whole lot more accessible to the average person. And the judicial branch should be accessible. I mean, it really should be. It's where society goes to resolve its differences, and people need to understand it. And I applaud you for the way you do write your decisions. 30 years as a lawyer, is that how many there were?
24.
24, not that you're counting, but
right.
24 years as a lawyer. You saw a lot of judges in that time. What did you think of the quality of the bench, and how did that prepare you? How did that prepare you to be a judge?
It was uneven, and at the beginning, in particular, the early years when I was, one of the few women in the courtroom, it was very troubling. You'd go before a judge, and you knew you lost the minute you walked in the door. You were raising claims that he basically didn't approve of. He didn't approve of your very existence. In the Sachs case, we found out many years later that the judge met with the prosecutor every morning to figure out what I was going to do. No one knew that, and so the standards of ethics were different. The extent to which judges were willing to even hear civil rights or criminal defense kinds of arguments was different. There were obvious exceptions to that, but I think sometimes that when people thought that I would go from an advocate to being a totally biased judge, on the other hand, they didn't understand the impact of that on a young lawyer. I did not want to be like that. I knew how much I treasured the courtroom, how much I treasured the courtroom as a neutral space, as a space where people could claim rights and claim constitutional values. And that's what shaped me as a judge. It was not the judge who was, questioning me and making jokes and turning to the police officer and laughing, which happened a fair amount. So it shaped me as a lawyer, because that's part of the reason you went to the press, by the way, is you needed people you wanted the press to understand what was going on in the courtroom. And the only way you were going to do that was to talk to the press directly. And as a judge, it shaped me. I cared very much about access to justice issues.
Matthew Stewart.
Yes.
The Charles Stewart case was probably the most famous case that this city has seen in the last 20 years. And you got a call one day from Matthew Stewart or his people?
Alan Dershowitz referred him to me. Yeah.
Talk about it. How did this work out?
It's actually very interesting. The Stewart case Charles Stewart was claimed that he had been shot just outside the hospital where he and his pregnant wife had gone for birthing classes. She was shot and killed, and the fetus inside her died. He was they thought mortally wounded, but he survives. He tells the police that the people who did this, that this was a black man dressed in a running suit. Now, it was very interesting. The city went crazy over that. The police appropriately furious about what had happened. The stories were that they began to shake down the black community, the African American community, to find out who had done it. And there were stories of illegal searches and abusive interrogation tactics. My husband actually had been asked by several members of the black community to investigate, to look into these kinds of abuses. Then I get the call to represent Matthew Stewart. Matthew Stewart had come forward and told the prosecutor that he believed his brother had done the killing, not this African American person. That was before I represented him. Charles Stewart then, the murderer, jumps off the Tobin Bridge, and all eyes focus on Matthew Stewart. So Stewart is calling me after my husband has now been involved with the African American community. He was up in arms at what police had been doing. And we actually had a negotiation, which is, could I take this case? Would it be seen as somehow devaluing what he did? And of course, he said it was okay for me to take the case. The story, there's this trial story here, but that chapter is really much more about stereotyping. Because there are two narratives when this murder took place. One was the urban myth of an African American killing two white people in a car. The other was the much more likely narrative, which is a man killing his pregnant wife. That actually is not an unusual narrative, because that's a time when a man feels that he's lost control. And that narrative actually had real corroboration for it. This is something that came out as I was writing the chapter. Real corroboration. One of Charles Stewart's friends had called the police after the murder and said, Charles had asked me to look for someone to kill his wife. He called the state trooper. State trooper never passed on the call. Yep. So it's an extraordinary story of, you have in mind, you think you're being objective. You may be doing this in good faith. You really want to get to the bottom of this. But you have a stereotype in your mind about how this happened, and you are rejecting all alternative narratives.
And meanwhile, Matthew Stewart had told a whole host of people who in turn told other people that he was in possession of her wedding ring and
the gun,
yeah.
where the gun was. His story was that he had been asked by his brother to participate in an insurance scam. Mm-hmm. So he went to the site. He didn't see Carol. He got Carol Stewart, the wife. He got a package from his brother, and they were going to make an insurance claim, claiming that they had been held up. And when he got to home, he realized that he had her wedding ring. He realized that she had been killed, and he had a gun in the bag. He didn't know what to do. This was his older brother. So the story was that for the next 6 or 7 months, he went around asking people's advice. This is a relatively young kid, asking people's advice. So there was a whole community. We counted about 100 people who knew his version of the story. But that didn't percolate up to the Boston police either, because the narrative they were going to go with was the African American assailant. And they couldn't hear this friend of Charles Stewart, much less Matthew Stewart's account, until he finally explicitly came forward. So it's a really, you talk about objectivity in the media, talk about objectivity in court, and you understand how stereotypes interfere with that objectivity.
Oh, absolutely, absolutely. We are going to open it up to audience questions as well. I don't know if any of you have the same history with Judge Gertner as I do, and you might be safer asking questions. So if anyone would like to ask a question, please step up to the microphone. And yes, sir.
You're a respected, honored lawyer, and you're leaving, a judge, and you're leaving. Why?
So one reason is to speak. I want an opportunity to speak without being worried about its impact on my judging. Brian may not know this. I have at least 2 more books in me, and one is about judging, and I think it will be a surprise for people to hear about what judging is like at this time. The other is a personal decision. I want a new adventure. I turned 65 a few weeks ago, and I want another adventure, and I'm not sure what that'll be.
Anybody else have any questions up there? Feel free to step right up to the microphone. Yes, ma'am.
Good afternoon, Judge. Elder James, back in Springfield, Massachusetts. Maybe you don't remember me, and that's okay. What I do want to say is I've been a lawyer for 24 years as well, and have been an advocate, have felt many of the same things you felt walking into a courtroom, particularly when I was 30, and knowing, depending on who the judge was, that I had no chance of even being heard. I do want to say, however, that when I mentioned Springfield, you came out to represent a woman, and her defense was that she was a battered wife. And at that time, we, of course, welcomed you and tried to make Springfield as hospitable as possible for someone from Boston. And I have to say that you were not only a star attorney at then, and I'm talking about 25 years ago, but you were also someone that remained the defense for battered women. And whenever someone talked about, well, I think I might have a battered wife defense here, you came to mind. Nancy Gertner, call Nancy Gertner. So I just want to say I can't wait to read your book, and it is certainly an honor to know that you're going also on a, on a new adventure. It's good for you. I think we need that, and thanks a lot.
Thank you. Thank you very much. Thank you.
Yes, sir.
And Judge, the obvious purpose of the criminal system is to prevent bad behavior. One of the things we do is take people who have been convicted of bad behavior and put them in prisons. And yet our prisons are full, and they're becoming a burden on us. And I was wondering if you have any suggestions as to alternative ways of being able to prevent bad behaviors without filling up prisons.
So I'm still a judge, and that means I have a 2-minute pause in my brain before I can answer. But for the past 17 years of being a judge, I've seen up close and personal how troubling our criminal justice system has been. This is not a quote from me, but others have talked about, the greatest incarceration of African Americans since Reconstruction. That was the drug laws have accomplished that. And someone else had described this as the American experiment in mass incarceration. There's no question that we're sending nonviolent offenders to jail in ways that we should not, at a pace that we should not. There's also no question that the prisons, you think about the budget cuts. The budget cuts in prisons means when I recommend that some woefully addicted addict goes to prison, he's done something terrible, but get drug treatment in prison, more and more now, nobody's getting anything in prison, or the lines are too long. So on the one hand, we're putting people away who are nonviolent and wasting resources. No greater authority than Newt Gingrich in the Washington Post wrote that in fact we're wasting our money on putting these kinds of offenders in prison when we have alternatives. The alternatives would be drug treatment. When somebody's an addict and does things, robs a bank, it's not a surprise why they've done that. Their addiction is responsible for it. We know how to deal with that. So many of the people that I've sentenced were people who were dysfunctional before they went into prison, come out, even more dysfunctional. We know that that the criminal justice system is being asked to make up for the profound deficiencies in our mental health system and social services. So we know how to do alternatives. We think we understand what they are. We can talk about evidence-based practices, the things that work. One thing we know is that prison, for the most part, doesn't work. I see in the audience one of the prosecutors that appeared in my court, and one of the first cases I had, which I will write about as a judge, was a 21 defendant gang case out of Boston. There were people who were very violent. They went away for a long time. And then there were people who were dealing crack in the hallways of their apartment buildings. They'd roll out of bed in the morning and start dealing crack. They all had dropped out of high school. They all had no skills. And this was what they did. I've tracked them. I sentenced them all about 10 years ago. I've been on the bench for 17 years. I have tracked all of them. Only one has succeeded. They've gotten out of jail. Only one has succeeded, and that's because he became an over-the-road driver and is traveling around the country. So we have to do something better. We don't have the resources to do it, and this approach is not working. But it's again, I'll speak more September 2nd.
Thank you.
But along those lines, do you agree with many in law enforcement that some of the gangsters on city streets, they may never be rehabilitated? The most important thing is just to get them off city streets?
There's no question that that's also true. 20 years ago, or 30 years ago, when people believed that everyone could be rehabilitated, and the reaction, mandatory minimum sentencing, is a reaction to that overblown, idealistic view about everyone. I'm not talking about that. I'm saying you can identify particular people, nonviolent mostly, who can benefit from job counseling, addiction treatment, etc. It won't be perfect. We will make mistakes, but it seems to me much less dysfunctional than really imprisoning. We imprison our incarceration rate is higher than almost every industrialized country, and I believe except Russia and China. They incarcerate more. That should give us pause.
Are you worried at all that it's too easy for judges just to give the max to escape public scrutiny?
Well, that's one of the things I want to talk about. The model of the activist judge who will be lenient and then wind up being on 24/7 news coverage, as the worst judge in the galaxy. That's not the problem. The problem is, it seems to me, highly punitive sentencing to escape criticism. You won't be criticized, and you probably will not be reversed on appeal. It's the other side that's much more difficult, and I think that the default becomes, in these very highly politicized times, the default is send these people away, and that just doesn't make sense.
Yeah, that was a great question, sir. We appreciate it. Yes, sir.
Great. Judge Gertner, thank you for being here today. And obviously you have been a trailblazer for women the last 25 or 30 years. I wonder, now that you're moving on to a new part of your life, if you have an interest in speaking about, or maybe you've already started to speak about, the treatment of women outside of the United States. We've learned a lot in the last 10 years, particularly in the Middle East, in Afghanistan, the repression of women there. Is that part of your future, too, to talk about that?
And I have squeezed in some international human rights work while I'm a judge, and I'd like to do much more about that. It has been a great advance to begin to see violence against women as a human rights issue, and I do want to work. Harvard will give me much more freedom to be able to do that than the courts did. So there's such an incredible disjunction between the rights that we characterize as our treasure in the United States and what we see outside the United States. So I travel to China a fair amount, which is complicated. But yes, I want to do more of that.
Great. Thank you.
Looking forward to your next role at Harvard. Do you see that maybe as a possibility for a learning experience for yourself, insofar as it might be a petri dish for the professional culture that shrinks the pool, so that these affirmative action kind of questions are being raised about choosing your successor, so that even though women are outnumbering men at law school, there's still a smaller pool to choose from, say, your replacement?
You know, it's interesting. I don't think that there's a smaller pool of women in their 40s and 50s to become judges. I actually think that's the pool that has been produced from 50% of the law school classes being women all these years. So I don't think that's really a problem. Whether there's the political will to create a diverse bench is another question entirely. I can say categorically that if I had to go through the confirmation process that many of the current candidates had to go through, and if I had to do that without Ted Kennedy at my side, I wouldn't have done it. Ted Kennedy is the reason why I'm a judge. Not just because of his presence, but he was determined to put on the bench someone who had this background, and which is the reverse of most of the political calculations that senators are making today. So while the pool is there are lots of qualified women, lots and lots of qualified women and minorities. The question is the political will, and that I am very troubled about.
I see. Thank you.
It is a senior senator, correct, who recommends
right.
judgeships. Could you share a little bit about your meetings with Ted Kennedy on this?
Well, you know, I didn't know him beforehand. I had no connection to the Kennedy family except for where we live. But he had a merit selection process for 5 vacancies. I applied fully expecting to be rejected. In fact, there's a funny story at the beginning of the book, which I love to tell. I was on a panel with Sonia Sotomayor, and the Yale women wanted to know, how does one become a judge? And she goes first, and she says, well, you graduate this wonderful institution. You do very well. You go and work for the government. You work for a big firm. You have your opinions, but you're cautious about how you express them, and you become a judge. Then it was my turn. I say, you graduate this fine institution. You clerk for a judge. Then you represent the first lesbian, feminist, radical revolutionary accused of killing a police officer you can find. That would be your first case on prime time. You do every abortion case in the Commonwealth of Massachusetts. And then for the final coup de grace, you marry the ACLU. And you become a judge. So there was a merit selection process. 4 vacancies were filled rather easily. All of a sudden, there was a 5th vacancy. I had an interview with Senator Kennedy, who talked about my background. And then just as we were finishing, he's standing up, and everyone who was rooting for me, all his staff who was rooting for me, sort of breathed a sigh of relief that the interview was over. And so finally I said to him, Senator, I have a bone to pick with you. At that point, they're all going, oh, my God, what is she doing? And I said, if you want to honor a civil rights or a criminal defense career with a judgeship, you need to do that. You need to honor this kind of career with a judgeship at least once. It doesn't have to be me, but somebody has to get that so people, the next generation, will know that these are important career paths to take. I'm told that that's what did it for him.
Yes.
I've been a juror once, and it was in your courtroom. It was a civil case, and the person who brought the case was representing himself. And it took 8 days, and there was a lot of sidebars. And I just want to say I thought you did a beautiful job with this situation. Does that happen very often, that there are people who represent themselves?
No, it doesn't happen. And people don't understand the reason why we appoint counsel is because it's very difficult to have someone who is representing himself in a courtroom. Very, very difficult. Slows the proceeding down, creates error. So part of the reason why we very, alone among many of the major countries, spend as much as we do on appointed counsel it actually makes the proceedings fairer and, in one sense, more efficient, because you don't have the kind of problems that you describe. But it's very, very difficult. In fact, my first case as a judge, I made the mistake of having a pro se defendant, and I was only a judge. This was my first trial, and I kept on objecting. I would object. Someone would say something, there would be an objection from me. And I had to finally, there were police officers in the back who were just falling apart laughing. And so finally, I began to do abstain, which was objection sustained. Oh. That was as close as I could get to bringing the two roles together. It's very difficult.
Well, when you sit on the bench and you watch lawyers go at it, do you ever want to just jump in and say, why are you acting like this? Or why aren't you asking this?
Leap over the bench and intervene? Yes.
You do?
Yes. Yes. But you learn to control that. And you go home to your husband and say, I can't tell you what happened today. No, you learn to control that.
And what kind of relationships do you end up forming with collective juries? Can you look over and see that it's an engaged jury or that it's not? Or I assume there's a special way that judges treat these panels.
Well, I mean, I actually think that there's a connection between my closing arguments and my judging, because I love to talk to juries, and one of the things I've tried to do, if you think judicial opinions are not written in English, wait till you hear judicial instructions. Judges do instructions to the jury to make sure they won't be reversed. So the instructions make sense to the Court of Appeals and no one else in the world. So I love to talk to juries in English, but that comes out of the same kind of motivations that I had as a lawyer. I also allow the lawyers to talk to the jurors afterwards, so that they can get a sense of what they did right or
You do.
Or
you have them into the jury room?
You have the lawyers come up, but the jurors are willing to talk to the lawyers, and sometimes the case may be just too hotly contested, and they don't want to talk to the lawyers. But if they want to, then yes, I have everyone come in and talk about it. Which the jurors then don't feel like bumps on a log. They feel like they're part of a process.
Yes.
Hi. I just want to say something similar to some other people. The first case, I am an attorney, and the first case that I was involved in as a lawyer was second seating a trial before you. And it was my introduction to federal court. It was my introduction to how things worked. I was very fortunate to be working on this case. And one of the things that has stuck with me, and in fact, I emailed Mr. McGrory after your column and told you some of this story, that the humanization of your courtroom, of making everybody real and everybody valuable, including the judge, had the jury asking, apparently, to go out to lunch with the judge. And I know it made our client feel valued, and I know that for me, as a literally brand new lawyer, I had just passed the bar, and you permitted me to argue jury instructions to you, and it was simply the greatest gift I've ever had. I am not a trial lawyer, and that was one of my only trials that I ever did. But I think that a lot of the things that you did on the bench have affected me as a lawyer in rippling ways, because we're very different people, but in rippling ways that allow me to talk to my clients as equals and allow me to talk to prosecutors as equals. And so I feel like that has really affected my career, and I don't know how to thank you.
Thank you. Thank you. Yes.
Thank you. We're going to take these last two questions. Yes, sir.
Thank you. I've really enjoyed the talk today. I was intrigued by your idea of making all courtrooms allow the media and videotaping and so forth. It does feel like it might lead to some comments or tangential things getting taken out of context. So I'm wondering, what else can you do to raise the level of discourse around around law and the proceedings in courtrooms?
Well, I think judges should go on the road. Let me give you an example. One of the things that I spent a lot of time on was sentencing. What do you do after someone's convicted? Where do they go? What kinds of things do you do with them? And friends of mine in Australia have a program called You Be the Judge. And they literally have a defendant saying, the charge is this, the defense lawyer, the prosecutor, and the judge each presenting their position. And it's interactive, and the jury, the public has to pick a number. And what you find is that it is hard, that it is very, very hard. And it's almost like no other lesson is as important as that lesson. If all you heard was the charge and the man, you'd say 10 years. But when you hear about the person, it's a different kind of issue. So I think that this ought to be in schools, this kind of engagement. The closer you come to what judges do, the more you'll realize how hard it is, and the less you'll be able to caricature it. So that part of the engagement that I talk about, having judges speak, and what I want to do when I leave the bench, is to let people know how hard it is. The whole notion of what kind of judge was I going to be, well, I was a judge who believed in the things I believed in and struggled with it every day. A judge that doesn't struggle is a judge that doesn't know what he or she believes in, and it seeds into what they do. But I think that people have to know what the process is in much more detail than we've allowed them to know it.
Thank you.
Thank you. Yes, ma'am.
I have a follow-on question to that media question. I've been following the soap opera called the Casey Anthony case down in Florida. I call it a soap opera, but there is a current trial. A woman is on trial for having murdered her child, and it's running on television just 24 hours a day. And these commentators are all commentating on what she did, and yes, large numbers of us think that she's guilty. But that's the question. How seriously is she going to be able to get a fair trial given this level of media coverage? And therefore, are you an advocate or an opponent of media coverage like this, real time, of court cases?
I don't think that we can put the genie back in the bottle. In other words, we live in a world in which trials, particularly high-profile trials, are not just high-profile in that they'll appear in the newspaper, they will appear on television, they will appear on the internet, etc. I think we have to deal with that. I also am married to the ACLU, so I can hardly say cut off public access to the court. That wouldn't work at home. Wouldn't work. But I think my point is that we have to deal with it. We try to select juries. I never believed when I was a trial lawyer that when you told a juror, have you read about the case, and they said no, that they were telling the truth. I really do believe it now. I never believed that if you told them not to read about the case that they wouldn't, but I actually do believe it now. I'll have jurors who'll say, I was driving to work and I heard the name of the defendant. I just wanted to let you know about that. I shut off the radio immediately. So we have to be careful about how we select juries, but I think we have to deal with a world in which the media suffuses every aspect of our lives. And the way to deal with it is, as I said, this kind of jury selection. You can't stop the commentary, which is why what I tried to do in the case that I allowed video streaming, the significance of video streaming is, let's say there's a court website, and you could click on the documents that were filed yesterday, and you can click on the proceedings, and you can see it from gavel to gavel. So whereas the TV is going to take a snippet here or a snippet there, if you want to see the whole thing, you can watch the whole thing. But I'm in the minority on the federal court in that respect, and probably a lot of other respects too.
Thank you.
Thank you.
Thank you. I have a last question, though it's for the audience. we have a Senate election coming up in the year 2012. We have an incumbent, Scott Brown, and we have a need for qualified Democratic candidates. I'm curious if you think we're sitting with one right here. Judge Gertner is going to kill me, but my only interest is an interesting race. So we are going to conclude here. Judge Gertner will be signing books. If you follow the signs outside, I think it will lead right in the lobby right there. And I want to thank you all for coming. Thank the Kennedy Library, and most of all, thank you for writing what is a delightful, poignant, humorous, extraordinarily well-written book. So thank you very much.
Thank you. Thank you. You are a hoot.